Today's episode is sponsored by Real Estate for Life. We often see movies about corrupt police officers, corrupt district attorneys, witnesses paid or coerced to lie under oath, and innocent people going to prison, sometimes on death row, and some innocent people being executed. Most of us think it is just Hollywood making a great suspense drama. Unfortunately, the truth is far worse, and nowhere was it as tragic as in New Orleans, Louisiana. The reason was the longtime district attorney, Harry Connick Sr. Yes, the father of musician and actor Harry Connick Jr. Orleans Parish, under the tenure of Harry Connick, has the highest per capita rate of wrongful convictions anywhere in the United States. Successive assistant district attorneys have come under severe criticism for a pattern of civil rights violations, including so-called Brady violations, meaning withholding of exculpatory evidence to defense counsel and other ruthless and illegal conduct on a level as to stagger the mind. Who was Harry Connick? How did he get the reputation as the deadliest DA in America? How did he get away with it for so long? Hello, I'm Colin Heaton, military veteran, historian, author, and welcome to this episode of Forgotten History. Joseph Harry Fowler Connick was born March 27, 1926 in Mobile, Alabama, and moved to New Orleans with his family at age 2. By the 1970s, he had become a part of the city's political fabric. Connick ran against the then incumbent prosecutor Jim Garrison, known as Big Jim, standing 6'7". Garrison gained worldwide publicity when he unsuccessfully prosecuted a New Orleans businessman in connection with the assassination of President John F. Kennedy, and insisted that a massive cover-up was taking place regarding the assassination. Connick defeated Garrison in the 1973 election, and after he became the city's top prosecutor from 1973 to 2003, he had led an office that sent hundreds of black men to prison, many to death row, and many were innocent. And this office became infamous for its record of wrongful convictions. Along with his tough stance on crime, he proved, among the city's savviest politicians, and many powerful fellow Democrats owed him big time. When Connick took the helm on April 1, 1974, he established a screening division that threw 50% of the cases out because he felt the cases weren't sufficient enough to be taken to court. Basically, it turned out that many of these cases were not prosecuted because they included his political friends and donors, or their families who were charged with crimes who were let off, and they kept contributing to his re-election campaigns. As violent crime rates rose, Connick's prosecutors set a blistering pace, with some trials lasting only a matter of hours. Dozens of defendants were condemned to the state's death row, often with unreliable or even paid eyewitness testimony. Perjury by the state's witnesses and crooked cops was so common, it just became an accepted part of the legal process. Connick's prosecutors sent dozens of people to death row and made expansive use of the state's habitual offender law, and many were innocent. It was said that Connick tried to kill more innocent men than cancer. Connick won election to 5 6-year terms, and his favor and ability as a master connector helped catapult political careers, said former Mayor Mark Morial. Morial, president of the National Urban League, had been friends with Connick since the mid-1960s, when Connick and Morial's father, Dutch Morial, worked together as assistant U.S. attorneys. But let's look at the web of corruption within Connick's sphere. Terry Songy, a project manager for Johnson Controls Incorporated, was a central figure in a scheme to skim hundreds of thousands of dollars from an $81 million energy efficiency contract. This was done during former Mayor Mark Morial's administration, and Morial and Connick, who had been friends for decades, were involved, and the corruption ran very deep. Terry Songy was the first major player to turn state's evidence in the biggest City Hall scandal in decades. Morial himself was also the first African American to be appointed a judge in the state of Louisiana. Easy for a Democrat in that city. Songy was sentenced to 6 months in prison in order to pay $70,344 in restitution to the city and federal governments by U.S. District Judge Sarah Vance on Wednesday, August 20th, 2008. Songy was the last figure sentenced in the scheme to loot the city's energy contract with Johnson Controls Incorporated, which wound up producing more than a dozen convictions. If you are moving to a warmer state or just a family-friendly region, contact Real Estate for Life to work with one of their 1,400 conscientious, experienced agents in the U.S. or Canada. Go to realestateforlife.org and don't forget to mention you heard it on Forgotten History. Also, from Real Estate for Life's one-stop shop, you'll find principal vendors for financial and real estate planning, new mortgages and refinancing, Christ-centered healthcare, and more. So, visit realestateforlife.org today. Other Connick colleagues in crime who were convicted including former Property Management Director Carrie DeKay, restaurateur and political operative Stan Pampy Barry, and, indirectly at least, then City Council President Oliver Thomas. But let's look at his cases. In the case of Shareef Cousin, Connick's attorneys withheld a key witness statement from the defense that would have exonerated the accused, arguing that the prosecution was under no legal obligation to disclose such information. A clear Brady v. Maryland violation. As a result, Cousin was put on death row at the age of 16, but the conviction and death sentence were overturned after 4 years in 1999, mainly due to a whistleblower. He was lucky. But dirty tactics by some of his assistants who practiced legal malpractice with his blessing would come to haunt his legacy. Connick's office accounted for 37 death sentences after capital punishment was reinstated in 1977. According to available records, favorable evidence was withheld from 9 of the 36 cases, or 25% of the men sentenced to death in Orleans Parish from 1973 to 2002. 1 in every 4 men sent to death row by the New Orleans DA's office from 1973 to 2002 was convicted after evidence that could have cast doubt on their guilt was withheld from them at trial. Yes, 4 men, about 11%, were completely innocent. 4 of those defendants were executed, and 4 others, including ex-New Orleans Police Department officer Antoinette Frank, remain on death row. 1 died of natural causes while on death row. Convictions for 28 other inmates condemned under Connick's record-setting tenure have been reversed due to prosecutorial misconduct, with 4 of those on death row being exonerated. Consider the case of Dan Bright, who was arrested and convicted of first-degree murder in 1996. What the prosecution withheld and the jury never heard was that the FBI learned the identity of the real killer through an informant who identified someone else. Though Dan's attorney suspected this other man, they were never aware that the FBI had corroborated their suspicions. Additionally, the DA's office suppressed the fact that their only eyewitness was himself in violation of his parole at the time of his statement to police and was allegedly working as an informant. Dan Bright spent 8 years behind bars, much of that time on death row before being exonerated. The man identified by the FBI was never prosecuted. He was protected by the police and Connick's office as well. When getting into the depths of New Orleans Democrat corruption, this is one for the books. Curtis Kiles was wrongfully convicted in 1984 of murder and sentenced to death in New Orleans, Louisiana. After Kiles' first trial ended in a mistrial, he was convicted after a retrial. Kiles' 1984 conviction of capital murder was reversed by the U.S. Supreme Court because of the prejudicial prosecutorial misconduct of withholding the evidence that the government's star witness was a paid informant who may have in fact been the killer. After Kiles' conviction was overturned, he was tried 3 more times, with each trial ending in a hung jury and a mistrial. and in each trial, Connick's office withheld information legally entitled to be given to the defense, although Connick denied any knowledge of it. Kyles was finally released after 14 years of imprisonment on February 1998 after the prosecution declined to retry him a sixth time. Kyles spent 11 of his 14 years in prison on death row. The Supreme Court used the Kyles case to clarify that the duty of a prosecutor to turn over favorable evidence cannot be avoided by allowing the police to keep favorable evidence in their files and not inform the individual prosecutor. Hence, if police kept evidence from the DA, then the DA was under no obligation to hand it over to the defense in disclosure. Well, that was their argument. Kyles was awarded $150,000 in compensation by the state of Louisiana. Raymond Franks was convicted in the December 1983 shooting death of Martin Carnessi during an armed robbery outside the home that Carnessi shared with his wife in eastern New Orleans. The wife, Faye Carnessi, had described the killer as having a white blotch on his cheek, that he was in his late 20s, and that he drove an old car. But her description of the suspect and the car he used differed at trial from her earlier statements to police and a grand jury. Given the fact that Mr. Franks was 20 years old, had no white blotches on his face, and drove a new car, these were important discrepancies. Information that might have affected the jury's decision, the motion to vacate said. While not an angel according to the motion, Franks had been arrested for the armed robbery of a grocery store, and he was later convicted and has not contested that verdict when he was implicated in the Carnessi death. Franks was tried twice for the Carnessi killing. The first jury in 1984 deadlocked, even after being told by the prosecutor the gun Franks had when he was arrested for the grocery store robbery was the murder weapon. That was false, based on a 1985 examination of the weapon by a federal laboratory, but Connick already knew it. Prosecutors tried Franks again in 1985, winning a first-degree murder conviction and life sentence. Franks' case was the latest in a series of conviction reversals sought jointly by DA Jason Williams, who touted his office's efforts to review long-standing convictions that resulted from non-unanimous jury verdicts, prosecutorial misconduct by the previous Connick Jr, which are now illegal in Louisiana, and other dubious convictions from decades ago. When these inconsistencies became known by a whistleblower, attorneys on both sides said evidence of inconsistencies in the only eyewitness's testimony was kept from the jury that convicted, a major Brady violation which Connick ordered. Another case was Dwight LeBron, who was arrested and convicted of first-degree murder and sentenced to life without parole. Connick withheld the fact that the only eyewitness had lied about their own identity when questioned by police, and in fact owned the car where the body was found. And this witness also had outstanding warrants for illegal gun possession and cocaine, which were dropped for their cooperation and testimony. But LeBron had an airtight alibi. He was in a public restaurant on the other side of town eating dinner with family members who all testified at trial. Nevertheless, the jury could not agree as to whether he should receive the death penalty. Connick had bought another conviction. Mr. LeBron was released and exonerated on December 10, 2001. When asked about the case, Connick refused to comment. Another classic Connick case was Norris Henderson, who was convicted of second-degree murder and sentenced to life in prison. Connick withheld contradictory evidence about the dying confession of the victim who identified the defendant. The conviction was reversed, and Henderson was granted a new trial, where he was again convicted. Once questions began to arise about the possible illegal actions of the DA's office yet again, but he was amazingly released on probation in a no-appeal agreement. Larry Curtis was convicted of the July 16, 1978 second-degree murder of Jack Gilmore and sentenced to life in prison. Connick withheld the fact that the chief eyewitness at trial, the victim's brother Donald Gilmore, failed to identify Curtis in the pre-trial photographic lineup, and in fact he picked another man. That conviction was reversed and he was granted a new trial. Wilbert Parker was convicted of second-degree murder and sentenced to life, but Connick withheld the fact that the victim had previously been convicted of aggravated assault, which corroborated the self-defense case presented, so Parker was granted a new trial. William Perkins was convicted of first-degree murder and sentenced to life. Again, Connick withheld an eyewitness statement corroborating the self-defense claim. The conviction was reversed and Parker was also granted a new trial. Reynald Muse was convicted of armed robbery and sentenced to 99 years, but Connick withheld the fact that the victim, who testified at trial, had failed to identify Muse in a pretrial lineup. That case failed appeal and Muse remained in prison. Philip Anthony was convicted on 3 counts of first-degree murder and sentenced to death, but Connick withheld from the defense that the trial testimony of the eyewitness was completely different than the pretrial statements made to police. The story had changed to fit the narrative. That case is currently under appellate review. Juan Smith was convicted of 5 counts of first-degree murder and sentenced to death when multiple assailants attacked people at a party. Connick failed to disclose evidence of the other suspects: witness impeachment evidence, previous suspect confessions, knowledge of prosecutorial prepared false testimony under oath by the chief eyewitness. The only eyewitness to this crime to identify Smith, Larry Boatner, gave inconsistent statements about whether he could recognize or identify Smith as one of the killers before trial. But at trial, he was suddenly quite certain, despite not giving an accurate description of Smith. Connick never disclosed this fact, and that case is still pending. In another very strange case, Ronald Monroe was convicted of first-degree murder and sentenced to death in a circumstantial case that had no evidence, only a purchased perjuring eyewitness. Connick withheld the fact that an alternate suspect had already confessed to the crime. The governor commuted the sentence to life in prison. Several cases being overturned were the result of misconduct or errors by Connick and his prosecutors. 19 more men on death row have had their sentences overturned or reduced as a result, but in many cases, it was corrupt Democrat judges who allowed these events to unfold. Judges, like DAs, are elected, and appearing tough on crime is the way to get reelected, even if they have to prosecute innocent people to keep their numbers up. Connick, a true Democrat racist, hid his feelings to create the image of his fair and balanced, tough-on-crime positions by making friends with the local black blues scene musicians and business owners. Former Judge Calvin Johnson said he agreed with the idea that race and racism had so much to do with the justice system regardless of what players you're talking about. But Connick had his black supporters, and of course they were Democrat politicians and donors. Harry Connick's deep-seated corruption became so infamous, Barry Scheck of the Innocence Project took special interest in him. There is no better case to illustrate Connick's methods than the capital prosecution of John Thompson. In 2007, John Thompson was wrongfully convicted of the murder of Ray Liuzza and sent to death row by Connick due to evidence withholding. Kevin Freeman, a police informant, committed perjury in court testifying. Thompson won a new trial while awaiting execution after it was discovered that the former prosecutor revealed on his deathbed that he had concealed blood evidence from Thompson's lawyers at Connick's request to secure the conviction in his armed robbery and murder case. The evidence included lab results showing the perpetrator had a different blood type, and eyewitness descriptions of the murderer, which differed considerably from Mr. Thompson's physical appearance at the time of the crime. Connick knew all of this, yet allowed their testimony. After 18 years, Thompson was afforded a second trial and was acquitted after less than 30 minutes of jury deliberation and was awarded a $14 million verdict by a federal court jury. But the U.S. Supreme Court overturned the award on March 29, 2011. One of the dissenting justices, Justice Ruth Bader Ginsburg, noted that Connick's office had in fact committed a pattern of violations, failing to disclose exculpatory blood type evidence, failing to disclose audio tapes of witness testimony, failing to disclose a deathbed confession of evidence destruction by the prosecuting attorney, Jerry Deegan, and failing to disclose eyewitness identification of the killer that did not match Thompson. Connick himself insisted that he was quick to push for a new trial for Thompson once the evidence withholding came out, but it was he who had the evidence withheld in the first place. The public outcry, political fallout, and possible legal actions against Connick personally probably moved him to make that statement. The records do not show that he ever made that overture at all. But Connick and his assistant DAs fought tooth and nail to keep any and all exculpatory evidence out when appeals were filed, including emerging DNA testing. Suddenly, once any subpoena for evidence held in storage was ordered to be presented for testing on appeal, it often mysteriously disappeared. Also, Connick's office and the New Orleans, Louisiana Police Department, as well as the Orleans Parish Sheriff's Department, had similar problems with evidence. In many cases, they could not produce a chain of custody showing how the evidence was handled and preserved, if it could be found at all. One such case involved Isaac Napper, whose conviction for killing a University of Maine professor outside the Hyatt Regency in 1979 was overturned by the Louisiana Supreme Court in 1991 over a withheld police report. The most corrupt DA in American history never admitted that he or his office ever made a mistake. And he was probably right. They weren't mistakes, they were deliberate illegal actions to secure convictions, mostly against poor blacks. There's a saying, you'll never find a millionaire on death row. Sullivan Walter was convicted of aggravated burglary, forcible rape, and crimes against nature. Physical evidence and eyewitness identification were the case. The DA withheld the lab results, identifying the perpetrator as a possible non-secretor, whereas Walter was not. Walter's case dragged on for 11 years before his conviction was finalized and the conviction upheld, a situation still in great doubt due to science. This also brought to light the allegations of possible bribery regarding appellate judges to ignore damning activity by Connick's office for political and/or financial gain. Eugene Lindsay was convicted of second-degree murder and sentenced to life in prison, but Connick withheld key witness pretrial statements. His conviction was reversed and he was granted a new trial. Alfred Oliver was arrested for kidnapping and armed robbery, but granted a new trial after DA files surfaced showing extensive inconsistencies in the stories of those who accused him, suggesting they fabricated the entire event. William Perkins was convicted of first-degree murder but granted a new trial after suppressed evidence from DA files emerged, suggesting the probability from the police investigation that he fired his gun in self-defense. One case that also boggles the mind was that of Gregory Bright, not to be confused to Daniel Bright, and Earl Truvia, who were 20 and 17 years old when, in 1975, the DA prosecuted them for second-degree murder. The two men endured 25 years of wrongful imprisonment before withheld evidence finally surfaced. Even then, they spent an additional 2.5 years in prison with their cases in court before they were released. The state had suppressed evidence of the real perpetrator and the fact that its only witness was a paranoid schizophrenic with a heroin addiction. The witness against them was paid by Connick. Both men were well into their 40s when they were finally exonerated and released from prison in 2003. Floyd Falkins was convicted of armed robbery and sentenced to 30 years, but Connick withheld inconsistent eyewitness identifications, and his conviction was reversed and he was granted a new trial. James Carney was convicted of second-degree murder and sentenced to life. In this case, Connick withheld the fact that the key witness agreed with the DA to have battery charges against her dropped if she testified in court against Carney, a man she did not even know. That conviction was reversed and Carney was granted a new trial. In the case of mentally and physically challenged Thomas Mitchell Debue, he was convicted of 2 counts of first-degree murder for the killing of Niquika Miller, age 6, and Jamal Moore, age 11, and sentenced to death. His brother Edward James Debue was also tried with him but received 2 life sentences. Connick withheld eyewitness statements inconsistent with Debue's physical description and capabilities, and allowed uncorroborated testimony. But it seems that problems didn't follow far behind Connick, who himself had problems in 1989 when he was indicted on federal charges of helping out an illegal gambling operation by returning seized records to the owner. He stated that he returned the records to the man in question because he needed them to file tax returns. Ironically, it was rumored that Connick had a gambling problem of his own and owed a lot of money, which he parlayed into legal favors. But a jury acquitted him of all of that on July 25, 1990. In the strange case of one Catholic priest, Reverend Dino Senel, who admitted he would cruise the French Quarter looking for young men, but he insisted the sex was consensual and did not involve minors. He also was caught with a lot of child pornography. Connick refused to prosecute and said he did so to spare the church embarrassment. But Senel was eventually tried and acquitted on child pornography charges in August 1995 by Connick's office. Connick then announced on his 76th birthday that he would not be seeking another term. The issue was revived in 2014 when a murder conviction against Reginald Adams, imprisoned for 34 years, was reversed. Attorneys for the Innocence Project in New Orleans presented evidence that detectives and prosecutors in the case had withheld critical information before Adams' 1990 conviction. Adams later received $1.25 million in a court settlement. Bernell Jaluka, Kunta Gable, and Leroy Nelson were found guilty of the second-degree murder of Rondell Santenac in 1996, with all three teenagers maintaining their innocence since their arrest. They served 28 years for a crime they knew nothing about, and Connick withheld exculpatory evidence from the defense. He knew they were innocent. Connick knew there was an ongoing investigation into former New Orleans police officers Lynn Davis and Sammy Williams, two cops who helped commit murders to help their drug-dealing business partners. Records also revealed the pair were the first officers present at the scene of the shooting. Lynn Davis, a key target in an FBI undercover operation in the mid-1990s, as it emerged, the patrolman was a lead enforcer in a protection racket for city drug dealers operated by corrupt police officers. During the investigation, Davis was recorded on a wiretap commissioning a hit on a woman named Kim Groves, who had filed a brutality complaint against his partner Williams. Groves was murdered less than 2 months after the Santenac killing. The state's prosecution relied almost entirely on the testimony of a single eyewitness named Samuel Rayford, the man driving the car Santenac was shot inside of. Prosecutors disclosed that vital inconsistencies in his account of the shooting had been withheld at trial, as well as evidence relating to his credibility. Connick knew all about it, but he allowed the corrupt officers to testify and frame the innocent children. And he also knew that since there was no murder weapon found or gunshot residue, the boys were innocent. They were arrested just a couple of miles and 20 minutes away after the shooting and were convenient scapegoats. At an emotionally charged post-conviction hearing, prosecutors for the Orleans Parish District Attorney's Civil Rights Division presented evidence in court that linked the 1994 murder to disgraced former police officer Davis, who went to federal prison. Harry Connick Sr., the most corrupt DA in American history, died at home on January 24, 2024, a free man and totally unscathed by his criminal conduct, along with his fellow prosecutors, who put victory and politics over the freedom and lives of innocent men. Justice is not blind. It sees the balance in a bank account. Thanks for watching today's episode of Forgotten History. If you like this episode, please consider becoming a channel member or joining our Patreon page. This would help us offset the ever-increasing cost of production. As always, please like, share, and comment. And if you have any show ideas, please contact us, and we'll get back to you as soon as possible. Until next time.